Chevron versus Ecuador is the best answer to the question how brave you could be in changing the nationality of your company. In this case, Chevron, which is an American company, merged with another company that had an investment in Ecuador. And then the Ecuadorian government argues that Chevron has made no investment itself in Ecuador. And then the answer of the tribunal is that there is a difference between an investor and an investment. So even if Chevron is not an investor itself, it still has an investment, and it has intervened during the proceedings before the internal courts. This is a wonderful thing that says that you are actually free to play with different corporate structures. I don't say that you have to abuse, but you have a substantial freedom. Then another interesting point is the doctrine of timely and efficient remedies. Chevron has made two steps simultaneously. First, it appealed before the Constitutional Court of Ecuador, and then, at the same time, Chevron lodged a request for arbitration with the Permanent Court of Arbitration. So the position of the government of Ecuador is that Chevron had to wait until the end of the proceedings before the Constitutional Court, and then Chevron would get the right to go to international arbitration. The answer of the arbitration tribunal is the timely and efficient remedies doctrine. The arbitration tribunal says that the remedy lodged with the Constitutional Court was not timely because it took 4.5 years to end the proceedings before the Constitutional Court. So the remedy was not timely. We have something like this in the case law of the United Nations Human Rights Committee. But still, the United Nations Human Rights Committee would require to prove that there were little chances of success. And then, what is an efficient remedy? And this is very important because it is different from everything what we have seen before the United Nations Human Rights Committee or the European Court of Human Rights. So the arbitration tribunal says that the constitutional remedy in Ecuador was not efficient because it had no suspensive effect on the judgments entered by the lower courts. So since that kind of appeal could not stay the execution of the lower judgments, that appeal was not efficient. This is completely different from what we see before other human rights instances.